You just lost money right now because you haven't reviewed your security deposit policies. California just changed the rules again, effective July 2024. If you're still operating on old information, you're not just out of compliance, you're one tenant dispute away from a lawsuit that could cost you thousands. This isn't about protecting your tenants, it's about protecting your bottom line from avoidable legal fees and penalties. Effective July 1, 2024, California landlords are capped at collecting 1 month's rent as a security deposit for all residential properties. This is a hard limit. No exceptions. It doesn't matter if it's furnished or unfurnished. It doesn't matter if you think your tenant is high risk. This isn't a suggestion, it's the law, specifically Assembly Bill 12. Prior to this, you could collect 2 months' rent for an unfurnished unit and 3 months for a furnished one. That era is over. If you're still collecting more than 1 month's rent, you are in direct violation. Consider a scenario. You collected a 2-month security deposit of $5,000 on a $2,500 month unit last year. That $2,500 overage, it's now illegal. If that tenant moves out and decides to challenge it, you're facing not only returning the excess, but potential penalties for non-compliance. Your lease agreement, if it states a higher amount, is now partially unenforceable, and you could be forced to refund the difference immediately. This isn't hypothetical. It's a direct consequence of ignoring AB 12. Now here's where it gets interesting. What about existing leases? If you collected a larger deposit before July 1, 2024, you are not required to retroactively refund the difference. However, for any new leases or renewals signed after that date, the 1-month cap applies. Do not attempt to recharacterize any portion of the deposit as last month's rent or a non-refundable fee to circumvent this. California law is clear. Any payment made by the tenant, regardless of its label, is considered a security deposit if its purpose is to secure the performance of the rental agreement. Understanding what you can legally deduct from a security deposit is crucial to avoiding disputes. California Civil Code Section 1950.5 specifies 4 primary uses for a security deposit: unpaid rent, cleaning the premises to their condition at the beginning of the tenancy, minus normal wear and tear, repairing damage caused by the tenant beyond normal wear and tear, and replacing keys or other property if specified in the lease. Notice the recurring phrase, beyond normal wear and tear. This is your battleground. Normal wear and tear includes things like faded paint, minor scuffs on walls, worn carpet in high-traffic areas, or loose grout. These are the natural result of living in a property over time. You cannot deduct for these. But wait, there's a catch. If your tenant puts a fist-sized hole in the drywall, that's damage. If they leave the oven caked in grease and food debris after a year, that's beyond normal cleaning. If the carpet is stained irreversibly from a pet accident, that's damage. The key is documentation. Without clear move-in photos, videos, and a detailed checklist, it becomes your word against theirs. A 2023 small claims court survey in California revealed that landlords lose over 60% of security deposit disputes when they lack adequate documentation of the property's condition at move-in. That's a 60% chance you're eating repair costs that should have been deductible. You have exactly 21 calendar days after your tenant vacates the property to return the security deposit or provide an itemized statement of deductions. This is not 21 business days, not when you get around to it, but 21 calendar days, including weekends and holidays. If you fail to meet this deadline, you forfeit your right to deduct anything from the security deposit, even if the tenant caused significant damage. Imagine a tenant causes $3,000 in damage, but you miss the 21-day window by 1 day. You are legally obligated to return the full $3,000 deposit and then pursue the tenant for the damages separately, a much harder and more expensive legal battle. Your itemized statement must be detailed. It needs to list each deduction, the dollar amount, and a description of the work performed or the damage repaired. For deductions over $125, you must include copies of invoices or receipts for the work performed. If you perform the work yourself, you must include a good faith estimate of the reasonable hourly rate for the work and the hours spent. Do not just send a lump sum cleaning fee or repairs. That's insufficient and will be rejected in court. A well-prepared itemized statement protects you. A poorly prepared one invites litigation. This is your first and last line of defense against deposit disputes. A thorough move-in inspection, documented with high-resolution photos and video, is non-negotiable. This isn't optional, it's foundational. Have the tenant sign off on a detailed move-in checklist, noting every pre-existing scuff, scratch, and stain. Without this baseline, you cannot prove new damage occurred during their tenancy. California Civil Code 1950.5F mandates that you offer your tenant the opportunity for an initial inspection before they move out. This is often called the pre-move-out inspection. You must notify the tenant in writing of their right to this inspection, typically 14 days before their planned move-out date. You identify any conditions that warrant deductions and provide the tenant with an itemized list. This gives them the opportunity to remedy the issues themselves before moving out, potentially avoiding deductions entirely. This process might seem like extra work, but it's a powerful tool. If the tenant fixes the issues, you avoid the cost and hassle of repairs. If they don't, you have documented proof that they were informed and failed to act, strengthening your position if you need to make deductions. Property managers who consistently perform these inspections report a 40% reduction in security deposit disputes compared to those who do not. This isn't just about compliance, it's about dispute prevention. Ignoring the 21-day rule is perhaps the most common and costly mistake. As mentioned, missing this deadline means you forfeit all rights to deductions. Another critical error, deducting for normal wear and tear. California courts are extremely strict on this. If you deduct for things like faded paint, you will lose, and you could be penalized. A common tactic landlords attempt is to impose a blanket cleaning fee regardless of the property's condition. This is illegal. You can only deduct for cleaning necessary to restore the property to its move-in condition, minus normal wear and tear. Consider the bad faith retention penalty. If the court finds that you wrongfully withheld a portion of the security deposit in bad faith, you could be liable for up to twice the amount of the security deposit in punitive damages, in addition to the actual amount wrongfully withheld. This is explicitly stated in Civil Code 1950.5L. This isn't just a slap on the wrist, it's a financial gut punch. For a $2,500 security deposit, a bad faith finding could mean you pay the tenant $5,000 in punitive damages, plus the original $2,500, totaling $7,500 out of your pocket, not including their attorney's fees. This is why meticulous documentation, strict adherence to the 21-day rule, and a clear understanding of permissible deductions are not optional. They are essential for your financial survival as a landlord in California. Recap: to protect your assets in California, remember these critical points. AB 12 is law. As of July 1, 2024, the security deposit cap is 1 month's rent universally, no exceptions. 2. 21-day deadline. You have precisely 21 calendar days post-move-out to return the deposit or send a fully itemized statement with receipts. Miss it, lose everything. 3. No normal wear and tear. You can only deduct for tenant-caused damage and cleaning beyond normal use. Document everything to prove the difference. 4. Pre-move-out inspections save you. Offer the tenant a chance to fix issues before they leave. It reduces disputes and strengthens your position. 5. Bad faith is expensive. Wrongfully withholding a deposit can cost you up to double the deposit amount in punitive damages. Don't risk it. Your vigilance in these areas isn't just about being a good landlord. It's about being a financially secure landlord in a state that heavily favors tenant protections. Don't let ignorance or complacency cost you thousands. Powered by LeaseBase Intelligence.